Ladies and gentlemen, let's have a brief lecture on chat on these issues about um, the moral and legal approach to guide against investment regret. How to guide against investment regret, moral and legal approach. You can take it that way too. During this week review of mail, I received a letter from an older friend whose wife is a victim of a Ponzi scheme allegedly perpetuated in Nigeria by 28 years old Nigerian girl whose name is said to be Mrs. Ovaza Imo Jenuza, trading in the style and name of Ovaza Farm Produce Storage Business Limited, a subsidiary of Vasa Group of Companies Limited, according to the report. In that, my friend, older friend, said that the wife is under depression, deep depression, having sunk her savings into the Ponzi scheme. The alleged fraud. What is more, despite a high-level educational status of the victim, a British trained graduate and a holder of master's degree in business administration, she could not detect a fraud scheme. Having listened to his complaints, and as a principle, or as a matter of principle, I don't get involved in discussions or matters without first doing critical analysis of the situation of the case. So what I did, I asked my older friend if there was any documentation as regard to the investment. Let us examine what is Ponzi scheme in the first place. A Ponzi scheme is a fraudulent investment scheme which generates returns for earlier investors and with money taken from later investors, offering an unrealistic returns on investment to unsuspecting clients or investors. The impact of Ponzi scheme is enormous. As of 9th March 2021, the Nigerian Securities and Exchange Commission reported that more than about 3 million Nigerians lost 18 billion to Ponzi scheme operators. That is in Nigeria. It happens everywhere in developed countries and developing countries, but the greater impact is seen in developing countries or least developed countries because of the level of poverty. The causative factors to proliferations of Ponzi scheme. What are the causes of Ponzi scheme drive? The first, devastating impact of economic failure of a country. Bad governance, which enhances poverty. Lack of social security system. Most least developed countries like Nigeria, for example, do not have social security system. Increased use of online service to interact has also enhanced the situation or accentuate the situation of Ponzi scheme crisis. What are the specific impacts of Ponzi scheme on the society and the victims? Loss of income is one of it. Victim lost income, dislocation of economic status and amenities, mental health crises and depressions on the victims, suicidal action, public odium on the reputation of a country or the affected country, marital and family crises such as divorce, domestic violence, effects on children, education and scholarship such as forced school dropout, increase of criminality and indulgence in confusion. Victims may resort to self-help that leads to fetish rituals, murder, and mindset of committing fraud against other persons. Burden on law enforcement agencies and judiciary. The law enforcement agents and the judiciary system become overstressed. Emotional crises such as abandonment, resulting from abandonments by girlfriends and boyfriends, fiancés and fiancées who could no longer endure the struggling and devastating situation, as well as dejection by family members. Also, psychological trauma and outbreak. All these are just some of the specific impact of Ponzi scheme investment. Let's go back to the Uvasa's case, the legal implication on the victims. As I mentioned earlier, my questions to my older friend was whether there was no documentation guiding or concerning the investment. The answer was in affirmative. So I asked if I could be obliged with a copy of such contractual instrument, and I promised to keep it confidential since I hate that the matter is already before law enforcement agency for investigation, as it is sub judice to present such or display such to the public when the matter is before law enforcement agency or judiciary, whichever applicable. It is therefore wrong for an authoritative person to display such material. Fortunately, I was obliged with a copy of the investment contract. In a nutshell, a perusal of the document indicates that there are transparency and exemption clauses demonstrating a force majeure in the contractual instrument between the investor and the alleged scammer. Uvasa acted through Uvasa Farm Produce Storage Business Limited, a subsidiary of Uvasa Group of Companies. A transparency and exemption clauses that demonstrate a force majeure element in that contractual instrument. And investors entered into that contract without scrutinizing those contractual instruments. Listening to the story behind the sucker, there is a likelihood or strong indication that the Uvasa girl from outset set out to defraud innocent investors. Her motive may have been to dribble the investors via the Ponzi scheme mechanism to a point that she can successfully divest them of their money to enrich herself, but this remains within the realm of ethical morality reasoning. Even though law is an instrument that sustains justice, law and justice are two different things altogether. Law sometimes do hate legalizations of injustice. This is why you need to know how to deploy the instrumentality of the law to sustain justice against injustice, or to guide against outcomes that turn detrimental to any investment you enter into. I have some very pertinent observations to make about the Uvasa investment contractual instrument vis-a-vis the applicability of law. My older friend does not accept my contention The police arrest of the advisor girl is a mere matter of threat in any trivial sense, for as he pointed out, a crime has been committed and the girl must be jailed. The police has assured them that justice will be done and a fleet of properties she purchased from investors' money will be sold and monies returned to the owners. According to him, the Economic and Financial Crimes Commission is also interested in investigating the matter and prosecuting them. But I told him, arrest, torture, and all the extrajudicial administrative protocols do not guarantee a conviction. In actual judicial proceedings, the extension of the general terms will involve a question of the principle of the credentials of the business, which need to be inspected and juxtaposed with the principles of law. I make a valuable point that the rule of coercion, which is common in investigation stage of legal complaints, may be entirely different in pure law proceedings. In the judicial sphere, such is the position of victim's vulnerability may not be the primary consideration until the questions of pure law and technicality is thoroughly resolved. That is why, in a well-regulated state, restraint from arrest generally usually prevails until thorough investigations and findings whether a case is triable is established. It may be said, however, that many developing countries, such as Nigeria, the operations of law is exceedingly inefficient. That is why law enforcement engages in media prosecution and inordinate arrest before investigation. And that is why overpowerful citizens and corporations may be able to evade or resist or secure perversions of actual legal rules. The situation, however, by no means old in regard to when a matter has been subjected to judicial proceedings. When good lawyers who understand the law, its tenet and its procedures are involved as defense counsel, there may be risks involved on investment relations criminal trial and civil proceedings to the detriment of the investors or the victims. Even though in a country where intellectual poverty is a dominant consciousness, when a vast majority of the collegiate men and women, including lawyers, are no more different with periwinkle sellers of the 18th century in white market of Calabar in Nigeria. In their reasoning, such a country which is obvious that certain fallacy constantly involved in the reasoning with regards to law making and interpretation, the kind of a primitive system where people jump into conclusions and public sentencing of the accused and suspect whenever there is an arrest. Ultimately, in actual judicial proceeding, truly enough, its substance is an exercise in pure law and legal logic, not immorality, and that is what law is. Therefore, despite the many valid criticisms and circumstances of this advisor case, the alleged scammer of over 3 billion naira belonging to investors, innocent citizens who are just trying to earn a living through investment. In judicial proceedings, where legal rules are to be equated with the norms and interpreted in a non-contradictory fields of law in meaning and substance, the advisor girl may walk home. If not at the trial, at the appellate or apex court. This is because of the transparency and exemption clauses which demonstrate the force majeure clause in the contractual instrument she designed for investors. The investors voluntarily enter into such agreement without scrutinizing the terms of the instrument. All the alleged scammer may need to prove is whether it is true that there was a business failure of such circumstance beyond her control. If that is proven, she walked home at last. Investors would then lose out. When that cannot be proven, then she might be criminally liable. What if she can establish that actually there was a business failure caused by circumstances beyond her control, even though such a proof is fabricated or manufactured? So for this purpose, let me introduce you on how to the steps and measures to prevent or overcome investment and contractual losses. That is the preventive measures in overcoming investment and contractual losses. The first measure is an issue of character orientation, overcoming greed. The primary means that any investor, any person who intends to enter into a contractual agreement or investment in any scheme need to do is to learn to overcome over-ambitiousness. This is, however, a moralistic view and not law. It is greed that makes one to believe that if he invests $100, he will now make $1,000 within a month. If he invests 10,000 naira, he will make 100,000 naira, meaning 90% of the investment as return, without analyzing the possibility of such return. If you prefer free things, you are greedy. It means you have greed. It means there is no more difference between you and the scammer. You have the same characteristic that but operate in a different frequency and modus operandi. But this is, as I said, a moralistic reason. Let's go to the cardinal measure. The importance of lawyers in your pre-investment and pre-contractual arrangement. Before you sign any contractual instruments, before you purchase any property, undertake any business, investment, or partnership, make sure you involve a lawyer to scrutinize all business and investment instruments before you sign it. Before you sign it, allow a lawyer to scrutinize it. Law, in the most generic and comprehensive acceptation in which the term in its literary meaning is employed, may be said to be a rule laid down for guidance of one who have learned or it or practiced it. Lawyers are trained to understand the tenets, the procedure, and the applicability of law. Even if you are a professor of 10 different specialties and appear highly educated and may not understand adequately the intricacies of law embedded in a contractual instrument or investment scheme, the money you spend in consulting a lawyer at the pre-arrangement, investment arrangement stage is far less in value than what you will spend attempting to recover your losses. That is, if you are lucky enough to survive the tension and the psychological trauma that may result from such heartbreak that may result from such losses. Please find any kind of lawyer, whether a litigation practicing lawyer or academic lawyer. In fact, if you cannot find any lawyer around you and there is a law student, give him as an assignment. He will contact his lecturer who is either doubling as a practicing litigation lawyer or a solicitor or as an academic at the same time, or whether it's just a purely academic lawyer practicing or whatsoever. He will, as we hope, have the basic knowledge of any implication that may arise to the contractual instrument. Just find a lawyer before you sign any instrument, before you buy any property, before you undertake any investment. I hope this message finds you well. Please follow me at Cyprian Edward-Ekpo Dialectics and Treatise at Facebook, at Twitter, and Instagram. And if you want to receive more resource materials, especially the print aspect of it, please go to www.unicell.education and click Cyprian Edward-Ekpo Dialectics and Treatise for resource material, intellectual resource material, available in different topics, different dimensions, all together. Thank you and God bless you.